which does not constitute racism? Is that what you're saying?
Yes, Your Honor. I think it's just an opinion of the President of the United States.
Under Philippine laws, is there any law that penalizes racism?
I think, Your Honor, the Republic Act 9815, the law that domesticated the Rome Statute, meaning that the Rome Statute has been enacted into law in the Philippines.
Is the Philippines still part of the Rome Statute?
We have already, the President withdrew from the Rome Statute, Your Honor.
If somebody tells you, you go back where you came from, is that racism?
I don't think, Your Honor, that is a general statement.
So when the law professors in law school tells the law students who did not study, you better go home and plant kamote and go back where you came from, that is not racism.
I don't think, Your Honor, because it is addressed to all students and all persons.
All right. Thank you very much and good luck, Justice Mons.
Thank you, Your Honor.
Attorney Aricheta.
Thank you, Justice Tinam. Thank you, Justice Tihan. The next interview will be the Honorable Judge Toribio Ilaw Jr. Judge Ilaw, sir.
Yes, good morning. Thank you, Attorney Aricheta.
Good
Yes,
morning, Your Honor.
Good morning, Justice Ramon Bato.
Good morning, Your Honor.
All right, we have extensively interviewed you since the last previous interview was on September 11, 2019. Am I correct?
Yes, Your Honor.
Are there notable changes in your qualifications since your last interview? Any compensating credentials that this council may consider you this time to be nominated as an Associate Justice of the Supreme Court?
My prayer, Your Honor, is that the honorable members of the Judicial and Bar Council re-examine and take a second hard look on my overall credentials and my performance as a magistrate for 29 years, and my credential as an academician, Your Honor, for having handled subjects in the College of Law, in Silliman University, in the University of Cebu, and in the Philippine Christian University. And my overall record, Your Honor, of the disposal of cases, including the number of cases elevated to the Supreme Court and the number of cases affirmed by the Supreme Court.
All right, for the record, you started your legal career as a court attorney, then the MTC judge, went up as an RTC judge, and ultimately appointed as an Associate Justice of the Court of Appeals. All right, and for our record, you have more or less 9 administrative cases. And what caught me is the pending one, allegedly for gross misconduct, conduct prejudicial to the best interest of the service. violation of the Code of Judicial Conduct, gross ignorance of the law, and knowingly rendering an unjust judgment for issuing a temporary restraining order on the Ombudsman decision against Governor Tallado, filed by certain Norberto B. Villamin, dated January 12, 2017. It's still pending. Am I correct? Are you aware of
Yes,
this?
Your Honor.
Although you argued in your comment that the doctrine, such decision of the Ombudsman is immediately executory pending appeal, which does not apply to elective officials.
Yes, Your Honor. After
But
going into the...
it's still pending
Yes, Your
at
Honor.
the Supreme Court. And going over also on your record with respect your PDS, you have a deposits of 10,798,339.45. And your 2018 SALN indicating the amount of 12,378,112.14. By the way, what do your children do in the Court of Appeals? We have this attorney Randy Bato, Rexy Cesar Bato. Just indicated they're working at the Court of Appeals.
My son, Attorney Randy Cesar Bato, is a coterminous employee holding the position of executive assistant for Your Honor. And as a lawyer, he helps me in the research of cases. He helps me in the research of cases so that I can resolve the legal issues raised by parties in cases submitted for decision. My other son, Rexy Cesar Bato, is also a coterminous employee, and he helps me in the circulation of the draft decision to the other justices who are members of the division.
About who is this Shell Alma Ray B. Santillan?
She is my private secretary, Your Honor,
At the
and
Court of
also a
Appeals.
coterminous employee.
About
She
this,
helps me as a private secretary in the finalization of the draft decision.
about this Jenny Ann B. Santillan.
She is my executive assistant, assigned on the agenda, Your Honor, so that the cases or the rules of the cases will be examined by her. And also she helped me because she is a law graduate in the preparation of resolutions.
All right, is your land
Your
bank
Honor.
account, is your land bank account your payroll?
Yes, Your Honor. I have a payroll account and a separate savings account.
And when was the last time you withdrew from your payroll account?
Payroll, I think I have several withdrawals, Your Honor. One, when I invested in the premium bonds with the offered by the government through the Land Bank of the Philippines.
And where do you get your expenses from day to day when you seldom withdraw from your land bank account?
My wife is also a judge, Your Honor. So the my wife contribute to the expenses. Even my son, Your Honor, is a lawyer, and my other son also contribute to the expenses of the family.
Justice, would you
And we
agree?
are very, Your Honor, please.
Yes, please. Please continue. Sorry.
So we also very tight on matters of expenses. We do not usually, we seldom go out to eat our lunch or dinner in a restaurant. We stay at home. We just go to the local market to buy what we need.
Would you agree that you live a lavish lifestyle?
I don't think so, Your Honor, because we seldom travel. We see to it that we spend only what we earn and has to save for the future, Your Honor.
Alright, could you tell us about the time when you went above and beyond the call of duty to get things done?
Your Honor, please.
Could you tell us about a time when you went above and beyond the call of duty to get things done?
Well, recently, Your Honor, there is a pandemic, so that we are allowed to work at home. But then, in one case, when there is a need to resolve a pending motion for bail by an accused who is languishing in jail, then we have to report to office and call for a special deliberation among the members of the division and issue a resolution, Your Honor, within the period of pandemic.
Alright, would you agree that the lawyers as well as magistrates should be abreast with recent legal developments? Justice?
Yes, Your Honor.
And what was the last case decided by the Supreme Court you have read?
The decision, Your Honor, of the Chief Justice involving the validity of an information filed by a assistant city prosecutor without the approval of the city prosecutor.
All right, the new rules of procedure implemented by the court are now in place. Could you discuss the salient amendments to the revised rules on evidence?
Sorry, Your Honor, I have not thoroughly read, because that is just a very recent amendment to the rules on evidence. And after this interview, I would endeavor to secure a copy of that rules and study the rules, Your Honor. But I think the rules on evidence, on hearsay evidence, has been elaborated and mentioned exhaustively in that rule, Your Honor.
How about this case of People versus a client, decided penned by Chief Justice Diosdado Peralta, December 10, 2018? Are you aware of this? With respect to the constitutionally permissible airport screening search as defined by the court?
Your Honor, please, I'm sorry, I have not read that decision up to this time. In due time, Your Honor.
All right, my last question will be this. If you were to get rid of a province in the Philippines, which would it be and why?
Get rid, Your Honor. I could not think of
Yes,
a
province you
province
would
that
like
should.
to. All right, that was my last and final question. Thank you, Justice, and good luck again.
Thank you, Your Honor.
Welcome.
Thank you, Judge Ilaw. The next to interview Justice Bato will be the Honorable Justice Jose Catral Mendoza. Justice Mendoza, sir.
Good morning. Justice Bato.
Good morning, Your Honor.
As I have interviewed Justice Bato several times and extensively, I really have no question except that these are follow-up questions with respect to the answers you gave to the questions of Justice Tiham. With respect to the expiration of the franchise of ABS-CBN, you mentioned that there is a controversy. What is the actual controversy which would justify it being heard by the highest court of the land?
The actual controversy is the operation of the ABS-CBN, even without even
And-
after the expiration of a franchise granted by the
Can can it operate
legislative
without
body.
a franchise? Can it operate without a franchise?
Under existing law, Your Honor, I don't think it can operate.
So it cannot operate. So the cease and desist order, do you think, issued by the NTC was superfluous?
Well, in a way, Your Honor, but then there is also a decision of the Supreme Court to the effect that if a property right may evolve into a question of due process if the entity involved has invested so much and that there are substantial number of persons that would be affected. And so here there is a question on procedural due process. I'm not saying that it should be decided in one way or the other, but just I am saying that there is also a decision of the Supreme Court to that effect, Your Honor. Whether that should be applied in this case or not, then that is a matter that is left to the sound judgment of the honorable members of the Supreme Court.
Do you agree that the expiration of the franchise was self-executing?
I think so, Your Honor, because there is a period to that. And
So-
after that, then
So ABS-CBN was aware of the period.
yes, Your Honor, because that is by provisions of law.
And
So
they
it
and
expired.
actually they filed a petition, or they acted. They requested Congress to extend it, or to renew a franchise. So you agree that they were aware that it would expire on May 4.
I think, Your Honor, they are aware because even earlier than the expiration, so many bills were filed in Congress to that effect for the renewal of the franchise of ABS-CBN.
So, what is your opinion? Was the issuance of a cease and desist order superfluous? Because as you agree that it was self-executing.
I think so, Your Honor.
It was superfluous. There was
Yes.
an opinion all over the papers, radio, TV, that the cease and desist order was void. ABS-CBN was not ordered to show cause why it should continue operating. Is that do you agree with that opinion?
Well, for the record, Your Honor, that there was no show cause order issued by the National Telecommunication Commission
Yeah,
before
correct.
the
That is
issue
why
that order.
an opinion was rendered. It was aired. It was printed that the cease and desist order was void from the beginning because the ABS-CBN should have been heard first. Although you mentioned it was the expiration was self-executing. Do you agree with that opinion?
The fact that it expired, the franchise expired, Your Honor, then by operation of law, ABS-CBN has no more authority to continue its operation.
So there was no need to issue us a show cause order before issuing the cease and desist order.
No need, Your Honor.
So you do not agree that it is void.
I don't think so, Your Honor, because the NTC can motu proprio issue that order because of the expiration of the franchise. And the NTC can also apply the rule on taking judicial notice that the law, insofar as the franchise of ABS-CBN is concerned, has already expired.
Thank you. Justice Tiham also asked you if you pray to the Lord Almighty regarding your dream or your father's dream of being appointed. Do you believe in destiny or divine providence?
Yes, Your Honor, I do believe on divine intervention.
That
and
it
divine
will be,
providence.
ultimately, it will be His will that will determine if you will be appointed or not. And that we are just instruments. Do you agree?
Yes, Your Honor. Fully, Your Honor.
Okay. You're a gun holder, firearms. You're a gun owner. I know that. No, you have been joining Justice Hermosissima. Correct?
Yes, Your Honor.
Oh, I just want, this will be the last topic. Under Republic Act 10591, do you know 10591? It is the firearms law. So you will know. Firearms law. It requires that before a gun owner can be issued a license, he is required to allow the inspection of the premises where the gun would be kept. Is this valid? Is this a valid requirement?
Well,
Is it constitutional?
the matter, Your Honor, is would be would, the issue on the validity of that
Yeah,
regulation
requirement.
should be
Yes.
challenged
Yes. Oh.
because
What is your personal opinion? Is
well,
that a valid regulation requirement?
well, what the purpose of that
In
regulation,
our
Your Honor, is
constitution, you agree there is no right to bear arms. Do you agree?
yes, Your Honor,
And it is a mere privilege.
privilege,
Yes. So
and so
the
that there
state
could
can
be
put restrictions.
valid regulation, Your Honor, in order
Yes,
to
sir.
ensure the safety of the gun holder.
So how about that requirement to inspect the premises? Is that a valid requirement?
I don't think there is a compelling state interest that would justify that kind of regulation, Your Honor.
In the interest of peace and national security?
Well, I don't think, Your Honor, because that is a matter that is personal to the owner of the gun. If he
The
has
owner of
a
the gun.
fault,
How about the interest of the state, national security?
well, I don't think, Your Honor, that there is a valid, reasonable restriction or valid regulation insofar as requiring the owner of the gun to provide himself with a vault to store the firearm in his possession.
Suppose the gun owner executes a waiver. Is that
Well, that is
waiver?
well. I
He
think, Your Honor,
execute a
that is
waiver. Okay,
that's a
continue.
if he voluntarily waive, that is personal to the owner, and so that could be a valid waiver. So if the
Like,
firearms and
yeah.
explosives would require the applicant, then the applicant has to follow with existing rules and regulations before he can be issued a license and permit to possess a firearm.
I see. Like the JBC requiring you to execute a waiver so we can check, the JBC can check your finances. Is that valid?
Yes, Your Honor. I
Oh,
think it's a valid requirement, Your
we
Honor,
can
or
require
regulation.
you to sign a waiver, just like the state can require you to issue or sign a waiver with respect to the firearms. The same.
Yes, yes, Your Honor,
That,
because
that
that
is
is
a,
it.
that is your opinion.
Yes, Your Honor, because there's a personal matter that should be subject to waiver.
Okay. Anyway, I only ask your opinion with respect to the firearms. Being a gun owner, I think you're aware of Acosta versus Ochoa regarding searches of firearms, the requirement. Are you aware of that?
Sorry, Your Honor, I was not able to read that decision.
Justice Leonen. Justice Leonen will be voting. Recommendation only. Oh, you read it. It was promulgated last October 15, 2019, Acosta versus Honorable Ochoa. Okay. How do you keep yourself abreast of latest jurisprudence? Because you were asked by Judge Ilaw about Oaklane. That Oaklane case was an old case about the search at the airport in Lawag. And now I ask you about this Acosta case. You seem to forget or not aware. How do you keep yourself abreast of latest jurisprudence?
Well, we have this publication of the FILJA, Your Honor, so that the decision you cited by Justice Leonen is not, I have not read that because the FILJA bulletin in my position is only for the period 2019. But before
So
that,
it is
before
only
October,
you FILJA selection of cases very few. They choose very few cases, only leading cases. But
of
and they
course,
did
Your
not
Honor,
cover.
when I
How do you
do,
read? How do you keep abreast of so many cases like Oaklane? That's a very important case because it covers searches in airports. Yes.
well, general principles of law would apply, Your Honor, that
About the case of Justice penned by Justice Carpio about moving back? What are the
about
different situations? Different. Have you read it?
the, what, Your Honor,
Oh.
the,
The decision of Justice penned by Justice Carpio regarding moving vehicles. There are several situations. Have you read it?
yes, Your Honor, to the
Mm.
effect that moving vehicles may be subject to visual search. And if there is a reasonable ground to believe that you have firearms inside, then probable cause that a crime has been committed, then there could be a more extensive
That is
search of a
general
moving
rule.
vehicle.
Do you that is the general rule? You remember the different situations given by Justice Carpio? If you can remember
Unfortunately,
only.
I
Oh,
could not. There are so
mm,
many
okay.
cases, thousands of cases, Your
Oh,
Honor.
uh,
And I have to admit that I am also an ordinary mortal.
but you are aspiring for the Supreme Court, a position in the Supreme Court. Anyway, those will be all. Thank you very much, Justice Pato. And continue praying as according to you, it will be his ultimate will.
Yes,
And
Your Honor, I'm praying.
we are just instruments.
Yes, Your Honor, I
Okay.
would hardly double my prayer
Oh,
for divine intercession
okay.
and for the justices of the and the honorable members of the Judicial and Bar Council to consider me
Yes. Oh,
for the position of
but
an associate justice.
I suggest if you're still young, if you do not make it this time, continue reading the Supreme Court decisions, especially Oaklane and Acosta. And Acosta is personal to you. You're a firearm or a gun owner. Oh. Anyway, thank you very much. I took much of your time. Oh, that will be all.
Thank you.
Justice Battle. Thank you.
Thank you, Your Honor.
Attorney Aricheta.
Thank you. Thank you, Justice Mendoza. The next to interview the candidate is the Honorable Justice Congressman Vicente Veloso III. Congressman Veloso, sir.
Thank you, Your Honor. Good morning, Your Honors. Good morning, Justice Bato. You're
Good,
familiar.
mo-
Uh, you're
good morning,
familiar.
Your Honor.
You're familiar with the provisions in Article 8, Section 7, Paragraph 3, that a member of the judiciary or a judge must be competent, must be vested with the attributes of integrity, probity, and independence. You're aware of that.
Yes, Your Honor.
Okay, I will not dwell so much on integrity and probity because members of the judiciary are sued via harassment suits for simply deciding case against the complainant. I will dwell more on competence and your independence. Can you cite to me a case which proves your independence, Justice Pato?
Well,
A case you rendered which proves your independence.
there are so many cases, Your Honor. What I could remember is the case involving that also involves the former Chief Justice of the Supreme Court. In that case, the issue is on the enforcement of a foreign judgment. And when it was the Chief Justice before she was appointed,
Okay.
was a practicing lawyer. And so they were able to secure a judgment against the against an entity, and that judgment, that foreign judgment, is so to be implemented in the Philippines. Now, in that decision, I reversed the decision of a division of the Supreme Court because that case was ruffled to me after the division who earlier decided the case inhibited in that case. And so I reversed the decision of the division and applied the rule that the foreign judgment could not be implemented in the Philippines if it is contrary to public policy. The public policy involved there is that the Solicitor General hired the services of the former Chief Justice without going to the procurement law. And so that is contrary to the public policy, and that attorney's fees awarded to the Chief Justice should be returned. And CUA is doing something to return. At that time, that case is said to be a sort of a controversial case, Your Honor.
Okay, thank you for that. I also note from the papers given me by the Secretariat of the Judicial Bar Council that you already have a low case pending, meaning a low caseload as of January 20. And looking at comparing rather your caseload to the other applicants, one has 1,169, one has 400 plus, one has 379. I rather credit you as a competent applicant because of your 262 caseload as of January 20. But let me go to the other points raised by the members of the council. First is the question of the Honorable Justice Mendoza about Republic Act 591. You said a while ago that carrying a gun or possession of a firearm is a mere privilege not a right. Is that correct?
Yes, Your Honor.
Because of by what provision in the Constitution can you claim that
Your Honor, there is no constitutional provision allowing.
or other predators in the farm? Uh, you will notice that because of the circumstances there in the province, these poor farmers are not being apprehended for possession of a deadly weapon. Are you familiar with that?
Perhaps because, Your Honor, that bolo is used as a tool in the livelihood of a farmer. So that also there must be a law or an ordinance that would prohibit the carrying of bolo in order that the farmer could be liable for carrying a bolo. But because of the recognition of the fact that that is an instrument or a tool used by the farmer in his livelihood in the province, then that is allowed, Your Honor. The home of an individual, but then by and large, Your Honor, I think the government has preserved peace and order in the community and has acted on complaints filed by individuals who are victims of crimes committed by malefactors, Your Honor.
And aware that it takes as much as 30 years before the malefactor is finally incarcerated with finality. You're aware of that?
Yes, Your Honor, because of the dockets of the court or the number of cases that is being filed and the procedure to be followed in order to follow procedural due process, so that
That is
that's
why.
possible, Your Honor. But then, by and large, the cases have speed up. The disposition of cases speed up with the continuous trial being adopted and implemented.
I've got a lot of relatives and neighbors who have been victims of Akyat Bahay. They have never seen the malefactors identified in jail on the basis of a final judgment. How do you compare the setup we have with that of the United States of America? Because the democracy we have has been patterned from the democracy in the United States. As you are aware, they have very, in fact, they are so protective of the lives of the people there that people are allowed not only to possess but carry firearms outside residences. You're aware of that?
Yes, Your Honor.
And so we have also the same principle. U.S. Philippine governments. It's the prime duty of the government to protect the people. If a case is filed with you on the assumption that you finally will, okay, suppose you're now confronted by this issue at the Supreme Court. Again, viewed against the backdrop that there is a constitutional provision, and I'm citing section 4 and 5, article 2 of the Constitution, that it is the duty really of the government to protect the lives of the citizenry, to the point that even under the revised penal code, article 11, paragraph 1, paragraph, yeah, Paragraph 1 speaks of self-defense. Paragraph 2 speaks of the defense of relatives up to the fourth civil degree by affinity and consanguinity. Paragraph 3 speaks of defense of strangers. They are justifying circumstances. In the case of our citizens who cannot sleep soundly at home because of the notoriety of akyat bahay, especially kung nakadroga. Will you change your position that possession of firearm is not a matter of privilege but a matter of right by virtue of Article 11 of the Revised Penal Code and Article 2, Sections 4 and 5 of the Constitution?
Yes, Your Honor, I am open to that, especially if the law would be passed by Congress,
So,
especially providing that it is a right of every Filipino citizen to bear arms to protect himself and his family.
are you aware that it is now difficult to even secure a license for a firearm to be possessed at home?
Well, in my experience, Your Honor, I was issued a permit to possess. I was also issued the permit to carry my firearm, Your Honor.
Because you're a member of the judiciary, an ordinary citizen cannot just secure a license to possess. And worse is the fees have jacked up. But go to another point, Your Honor. It was mentioned about this mass media. Congress, until now, has not issued a franchise because the franchise of ABS-CBN already expired. Renewal is already academic. It has not issued. And I heard that ABS-CBN went to the Supreme Court. Are you aware of the kind of case filed with the Supreme Court?
Yes, Your Honor.
It was a case of what? Certiorari, prohibition, mandamus?
Well, I think, Your Honor, the first case that was filed was Coranto. Then the ABS-CBN later filed a petition for certiorari.
Okay. Certiorari. My recollection of certiorari when I was with the Court of Appeals is that it applies only to cases rendered by agencies uh, endowed with the power to issue decisions because they are judicial, quasi-judicial bodies. Is that correct? Is my recollection correct?
Yes, Your Honor. But then with the expanded jurisdiction, if there is grave abuse of discretion amounting to lack or excess of jurisdiction, then it also applies to governmental action. And that has been the decision of the Supreme Court in several cases.
I am not aware because I have been, the rules of court is just like a Bible to me, just as the Constitution is. I'm not aware of an amendment made to Section 1, Rule 65, and my recollection is still certiorari would involve cases rendered by judicial, quasi-judicial bodies tainted with grave abuse of discretion amounting to lack of jurisdiction or no jurisdiction at all. I did not, unless you tell me that the Supreme Court has already committed the sin of judicial legislation. I am not aware that it has amended Section 1, Rule 65. So my recollection is it only applies to decisions of judicial and quasi-judicial bodies. But suppose they will file a case of prohibition under Section 2, Rule 65. Would that apply, or would that be a proper remedy?
Prohibition is a remedy available to prevent the performance of an act, Your Honor, so that the act has already been consummated by the issuance of that closure order, so that the available remedy would be certiorari to question that governmental action.
But as to functions, my recollection of Section 2, Rule 65 is it applies to agencies performing judicial, extrajudicial, and even ministerial functions. So in that regard, the Congress could qualify, except that it is not, in my view, the ministerial function of Congress to issue a franchise, viewed against the backdrop that we have limitations under Section 11, Article 12, and we also have Section 11 of Article 16 as to mass media ownership, etc. In the matter of actual controversy, you were asked by the Honorable Justice Mendoza if there is an actual controversy that exists between Congress and ABS-CBN. Is there an actual controversy?
Well, in a technical sense, Your Honor, then there is an existing controversy on the issuance. But then, insofar as the actual controversy that is just justiciable, then I think with the expiration of the franchise of ABS-CBN and taking into account the plenary authority of Congress to grant or deny a franchise, then there is no justiciable controversy.
An actual justiciable controversy will eventually be resolved on the question of cause of action, presence or absence of a cause of action. Does ABS-CBN have a cause of action against Congress for its refusal or failure, not refusal, for its failure until now to issue a franchise?
I don't think, Your Honor, because that is within the full discretionary authority, plenary authority of Congress to grant or to deny a franchise. And that is a matter of legislation. And in matters of legislation, that is addressed to the collective wisdom of the members of the legislative body.
Because also in Rule 2, Section 2 of the Rules of Court, in my recollection, a cause of action is defined as an act or omission by which a party violates the right of another party, meaning the aggrieved party. But here, who can be an aggrieved party in the matter of failure on the part of Congress to issue until now a franchise? Your Honors, that will be all for now. And good luck. I have been with Justice Bato for about 11 years, I think, at the Court of Appeals. In the matter of the requirements in Section 7, Paragraph 3 of Article on competence, integrity, probity, and independence, I cannot be a good judge because I have seen none. no derogatory uh, action or remark even against Justice Pato. The competence and independence, and I am satisfied with his answers. I've been listening to his answers to the members of the council. Thank you, Chief. Thank you, Your Honors, members of the council. That would be all for now. Thank you.
Thank you, Your Honor.
Thank you, Congressman Veloso. Thank you, sir. The next to interview the applicant is the Honorable Chief Justice Diosdado Peralta.
Thank you.
Chief
Good
Justice
morning.
Peralta.
Good morning, Justice Bato.
Good morning, Chief.
I have a few questions, some clarifications of your answer because of the questions of the other members. Now, my first question is this: when you rendered that decision involving the former Chief Justice, when was that?
I think, Your Honor, before or after the removal of the chief. I'm not very sure now.
But you are sure that impeachment proceedings have already started in Congress, or she might have already been removed by quo warranto when the decision came out.
Yes, Your Honor.
So that's clear. It was a decision that was rendered when she was no longer with the Supreme Court. Now you mentioned only a few cases or a few cases that are pending before you. Now, how do you declare cases unresolved cases? How do you declare? In all one, do you say cases are still unresolved in the Court of Appeals?
Well, the case, as far as the record of my docket is concerned, whether a case is submitted or not, that is recorded, Your Honor. And whether it was decided or still pending, that is also in the docket of the court.
But the justice can state or can declare or can keep the cases with you because it is the justice that will declare that the case is already submitted for decision.
As a matter, yes, Your Honor, but
if it is placed in your agenda and you do not release the agenda that this case is not yet submitted for decision, then that will be counted. Is the impression, is my impression correct?
yes, Your Honor, but under the rules, after the filing of the last pleading, then it is the duty of the court to issue a minute resolution that the case is already submitted for decision. And our division clerk of court is very up to date, Your Honor, on the cases. And so we also are very much involved in determining whether the case is already submitted or not for decision.
Now, there were cases mentioned in the questions of the members. May I ask you if you are familiar with the case that was decided by Justice Noel Tiham, a very interesting case, in the case of People versus Tagalog, or Boy Tagalog, or People versus Agkawili, alias Boy Tagalog. Have you read that case?
If I could not recall, Your Honor.
When you are in the Supreme Court and you come to the court, you must be familiar with all the doctrines. No? Your doctrines should be in your fingertips. You cannot just rely on the lawyers because you are alone in the deliberation room. And this case is very interesting because Justice Noel made distinctions between and among cases of sexual assault as a form of rape under the Revised Penal Code, acts of lasciviousness under the Revised Penal Code, and sexual abuse under Republic Act 7610. which case was further clarified in the case of People versus Tulagan. Both these cases are en banc decisions. You did not also read the case of People versus Tulagan?
I have read that decision,
So if you
Your
have read the
Honor.
case of Tulagan, because that case of Boy Tagalog is mentioned in the case of Tulagan, then you should be aware of the doctrines laid down in these two cases, because you are handling a lot of cases involving minors. And we have to clarify, because there are so many decisions, different decisions, classifying what crime is committed against minors. Now, the other
Now,
one
Your
is that,
Honor,
yeah, you have to
Your
read all
Honor,
these
now
cases.
I could recall that landmark decision of the Honorable Chief Justice in People versus Tulagan involving the minor who is 9 years old, and the accused who was charged of statutory rape and sexual abuse, sexual assault. And
But
the Honorable Chief Justice has clarified the decisions in the other cases rendered by the Supreme Court. The Makuta case and the Kawili case decided by the Supreme Court, and the other cases, Your Honor.
yeah,
But it escapes my mind, the the, the other cases, Your Honor.
so that's how important doctrines laid down by the Supreme Court, because you are guided properly. Okay. The other case
Yes,
is
Your
that
Honor.
I've been reading a lot of cases involving drug cases. Now there is this crime punishable by 20 years and 1 day to life imprisonment. Of course, probably you do not remember what's the crime, but it's a violation of Section 11, where the dangerous drug is more than 5 grams, but not more than 10 grams. And then the penalty is 20 years and 1 day to life imprisonment. Now, this is the common mistake of justices in the Court of Appeals. My question is that bailable or non bailable? 20 years and 1 day to life imprisonment.
Well,
Well, is it a matter of right or not?
the penalty, Your Honor, is not that is not a capital offense. It's not in life imprisonment or reclusion perpetua, so that that is bailable as a matter of right, and it is the ministerial duty of the court to fix the bail and to release the accused on bail.
The maximum penalty is life imprisonment. But most of the decisions that reach us, they would impose a penalty of 20 years and 1 day to life imprisonment. Probably they have not read an old doctrine as early as 2015, where similar penalty, where the courts, in the case of People versus Valdez, where the court said that the life imprisonment, that kind of penalty, is not the penalty. That is merely the maximum term. In other words, when you say 20 years and 1 day to life imprisonment, that is the range of the penalty. It's not the life imprisonment that is the penalty. It is merely the maximum. So it is wrong to impose a penalty of 20 years and 1 day to life imprisonment. You have to choose in between. So that's one of the cases that reach us, and coming from the Court of Appeals, and they commit mistakes on that kind of penalty. My other question is that during this pandemic, you were required to work from home. Am I correct? Were you required to
Yes,
work
Your
from home?
Honor. Yes, Your Honor.
Were there decisions that you penned, which will be submitted when we be in full operation by June 2nd, probably for promulgation?
Yes, Your Honor. There are already cases that I can promulgate on June 1. But having said that, Your Honor, last week I promulgated 2 cases.
Now, very good. Now, there are many suggestions during this pandemic about revision of the rules. in order to address the problems that we are facing during this pandemic. And one of the suggestions is to amend the notarial law, so that we can get away with physical appearance of the parties and even lawyers, and that we can do what they call the something like video conferencing in notarizing documents, so there will be no more physical appearance. What is your idea of that?
I think that that idea, Your Honor, is consistent with the present situation of the pandemic, that we have to adopt certain measures in order to prevent the spread of the virus. And I am open to that idea, Your Honor.
But the rule now, the President rule specially provides, even in the acknowledgement of documents, that the following parties personally appear before me. And that is one of the conditions, that is one of the requirements of documents that are supposed to be acknowledged before a notary public. So we will get away with physical appearance.
Yes, Your Honor. If teleconferencing is allowed in hearing cases, then there is no reason, I think, that there is a legal obstacle if we will amend that requirement on personal appearance, as long as it could be properly authenticated.
Well, what will happen now to those lawyers who were penalized for notarizing and acknowledging documents without their appearance? Because there were a lot of lawyers that were penalized because that is a violation of the notarial law. Shall we then set them free? Because there is a new rule allowing non-appearance of parties or witnesses, for that matter.
Well,
That is
that's a legal question. That is also a difficult question, Your Honor. If the
so
court
it's not
will
easy.
adopt.
It's not easy actually. It's not easy actually because there are many matters that have to be taken up. The other one is video conferencing. Now we allow video conferencing in some cases, right? Now, if we make it as a rule, would it be proper to apply video conferencing in all matters concerning criminal cases?
Well, Your Honor, that has been tested, tried, and it works.
Yeah, but there are some questions because the accused is always entitled to a face-to-face trial, and that has the right also to observe the demeanor of witnesses against him. That's why there is a face-to-face trial. And
But there is a decision. Yes, Your Honor, but there is even a decision of the Supreme Court when we apply the right of confrontation, the constitutional provision that it is the right of the accused to confront the witness face to face. But unfortunately, Your Honor, the Supreme Court did not agree with us and even allow teleconferencing involving a witness who is incarcerated in Indonesia.
Did you hear about service convention that we incorporated in the rule on evidence and rule on civil procedure? Have you heard about service convention? As we have already incorporated in the rule on civil procedure and the rule on evidence and apostille convention. You not have heard about?
Not yet, Your Honor, but I would secure a copy of that rules.
You were once a judge. You were once a judge, right? Okay.
Yes, Your Honor.
You encountered the problem of serving summons and services outside the Philippine territory, right?
Yes, Your Honor.
That was a big problem to us. That service convention has already cured that problem because we are one of the signatories in the Hague Convention. We are now allowed to serve the summons and notices outside of territorial jurisdiction through the repository in the foreign country. That's now in the rules. You have to read the new rules.
That's it. Yes, that's a good development, Your Honor, so that we would have no longer a problem on the service of summons on individuals who are residing abroad.
Apostille Convention. Have you heard about the Apostille Convention? That's it.
Not yet,
Not
Your
yet.
Honor.
These are the contracts where you do not anymore need to go to the embassy for the red ribbon or authentication. It will merely be apostolized, and then the document will be presented to us through the repository in the Philippines, or is the court administrator, and that document will not be admissible in evidence. There's no more need of authenticating it, and then try to prove that the document was presented to the embassy for authentication with that red ribbon. So the trial will not be.
Well, that would help a lot, Your Honor, in the disposition of cases.
The last one that I would like to ask you is your opinion on the creation of the Judiciary Integrity Board. Have you heard about the Judiciary Integrity Board?
Yes, Your Honor.
It was actually approved by the Court and Bank sometime in 2019 or 2018 rather, 2018. And we are now in the process of coming up with guidelines and qualification of standards of officials. If you are aware of that and you are in favor of that, are you aware of the salient features of the Judiciary Integrity Board? Do you think that
to my
yeah? And the other follow-up
to my
question,
knowledge,
yeah, the other question is that will that JIB board be enough tool to address the problem of corruption in the judiciary?
that can help a lot, Your Honor, in addressing the problem of corruption in the judiciary, because you have there a body that would be focused on conducting investigation and recommending to the Supreme Court the proper sanctions for those erring judges.
My advice to you is Justice, you come to the Supreme Court. The deliberation of the Supreme Court is much different with the deliberation of the Court of Appeals. You have to attend the deliberation always prepared, and there are many issues that crop up during the deliberation. So I suggest that you read well, you try to study some of the cases that we have decided, because these are important when you attend the deliberations, whether division, lawyers will not be able to assist you with the own. So that case that was asked of you by Justice Mendoza, that was penned by Justice Arquio, that is a very important case, because there is now a distinction between a public utility vehicle and a private vehicle, and a public utility vehicle that stops and allow passengers to board the vehicles while the public utility is traveling, no? And a utility vehicle that does not pick up passengers like taxi. If it is a taxi or private vehicle, then you apply the visual search. But if it's a public vehicle like bus, and pick up passengers along the way, then there will be a different. It's not only visual search you can do, but you can board the vehicle. So you read, this is a new doctrine by Justice Carpio, and everybody should know that doctrine. The other
Yes, Your
case
Honor.
is that sometimes they are not aware of doctrines. Have you read the case involving violation of dangerous drugs pertaining to Section 21? I think you're aware of Section 21, 9165, because that is the provision that is always raised by accused. Yeah, I think you're familiar with that.
Yes, Your Honor.
You also familiar with the doctrine that we laid down in People versus Lim?
Yes, Your Honor.
People versus Romy Lim.
Yes, Your Honor.
Yeah, but they are saying that that case is a ground for acquittal. I read in some cases that they are quoting the case of People Lim as a ground for acquittal. Do you agree with that?
I don't think, Your Honor, because the requirement in Lim on is there so that the prosecutor can build a strong case against the accused from the very beginning. So that
So you can,
actually helps in the
so you are
disposition,
correct, but
in the decongestion of cases, Your Honor.
so you're correct, but there are still those who insist that that case is a ground for acquittal. That's not for, that's for purposes of properly filing the case before arraignment. So that's only for the
Yes.
determination of where a case may be filed if there is a violation of People versus Lim.
Yes, Your Honor.
Now, one is, when you join the court, what would you like to introduce in order to address the perennial problem of court delay in the first level and the second level courts, aside from those that are already being implemented? That's my last question. You join the Supreme Court, what would you like to suggest or to introduce in order to address the perennial delay in the resolution of cases in the first and second level courts?
Well, before the trial court, we should be very strict in the enforcement of existing laws, Your Honor. Implementation of the law is required because we have so many laws, continuous trial, then we amend the rules of court in order to speed up the disposition of cases so that, for instance, in civil cases, if we do away with trial proceedings where all the witnesses would appear in one sitting, because we have now amended the rules on civil procedure in that that would speed up the disposition of cases, Your Honor, because that there would be no longer any requirement that you have to state only an ultimate facts. You can state now the law applicable, attach your documents, and so upon reading the all the pleadings filed by parties, the judge could already determine whether there is merit or no merit to the case. And so that would speed up.
So in short, you want to change the work attitude of judges.
Yes, Your Honor.
Thank you. That's all, Justice Bato. Good luck. And,
thank you, Chief.
I hope this time you will be included in the list of nominees. Thank you.
With your help, Your Honor. Thank you.
Thank you, Mr. Chief Justice. That concludes the interview for Associate Justice Bato. The next...
Do we still have time? If we will not continue, then we will not be able to finish the three candidates this afternoon. So we might as well continue. What's the wish of the members? Okay, continue. Okay, continue then.
Thank you, Chief. So the next candidate for interview is Court of Appeals Justice Priscilla Baltasar Padilla. The first to interview will be the Honorable Judge Franklin de Monteverde. Tonelea, nasaan na si...
Thank you, Attorney Ed.
Good morning, Your Honor.
You may begin asking your questions. Judge Frank, you may begin asking your questions. Thank you.
Okay, thank you. Good morning, Chief Justice and other members of the Council. Justice Padilla, good morning.
Good morning, Your Honor.
I was going over your medical records, and you were declared by the physician to be physically fit Am I correct?
Yes, Your Honor.
Yeah, but then when you had a chest X-ray, it was found out that you had an atheromatous aorta. Can you explain what that finding was?
I should admit that I really don't know what its meaning is,
Okay, so
but I was certified to be of
yeah.
good health, Your Honor.
So in short, you have no problems insofar as effective performance of your functions as a justice is concerned.
None, Your Honor.
Okay. By the way, Justice, when did you pass the bar?
I took it in 1984. The bar results were released the following year, Your Honor.
1985.
85, yes.
Okay. And I understand that you were included as one of those who were included in the top 10.
Fortunately, Your Honor.
What was your place then?
Number 5.
Okay. So from the time that you were, you passed the bar up to now, including your stint at the judiciary, how long have you been a lawyer?
1985 up to now, Your Honor. So,
Okay. So with the judiciary, how many years?
I started in 1996, Your Honor.
Okay. I understand that your first assignment as a justice of the Court of Appeals was in Cebu.
Right, Your Honor.
That's correct. Okay. Now, I will just ask some clarificatory questions on some of your entries appearing in your documents that you had submitted. And one of those is concerns rather an administrative case filed by a certain Thelma Chiong for alleged corruption inside the Court of Appeals.
Your Honor, please. It is not
Yes.
an administrative complaint. It's just a letter complaint filed by her with the Supreme Court.
Okay. Because what I have here is administrative AM number 07-4-05-CA.
Actually, it refers to the letter complaint of the
Okay.
said person. But until I left Cebu Station, no administrative complaint has ever been filed by her against any particular justice of the said station, Your Honor.
How long did you stay in Cebu?
From 2006, about 3 years, Your Honor, up to
3 years.
2009.
And when this case, or rather this complaint of Thelma Chiong was submitted, did it affect the integrity of the Court of Appeals there?
Not at all, Your Honor.
With you personally?
Not at all, Your Honor. I just continued my job, disposing of cases strictly on the basis of the merits and resolving them within the time frame set under the law. Okay. So I'm not at all affected, Your Honor, because I know in my heart, I'm not one of those being alluded to in the said letter complaint.
Okay, thank you. Now going to your PDS, you stated that this is the first time that you applied for the position of a vacant position in the Supreme Court.
That's right, Your Honor.
And you said that you were how many years in the Court of Appeals?
Tomorrow, Your Honor, it will be my 14th year.
14th year, okay. Now, why did it take you so long the time?
Well, it's my, yes, Your Honor. It's my personal decision to wait until I have reached the age of 60 and have become a chairperson of a division in the said court. Because by this time, I believe I have gathered enough wealth of experiences and that I will be more prepared for the post I am applying for, Your Honor.
Now, having applied for this position, what would you consider your biggest credentials that would convince me in particular to vote for you?
Among which maybe, Your Honor, is what you have mentioned earlier. I placed 5th in the 1984 bar examiner, a consistent honor student from primary up to law. I am also a legal educator, a law professor, a bar reviewer, an MCLE lecturer, and FILJA professorial lecturer. And in the recently concluded bar examination, I'm one of the bar examiners on civil law.
Okay. Now, going to your SALN, there were times that you submitted the same with a check on the box for separate filing, while there are years that you also checked not applicable. Why is this so? Are you not filing a joint SALN with your husband?
My husband is a private practitioner.
Okay, so that explains the thing. And you also listed some business interest and financial connections. What are these?
Actually, what I mentioned, like Call Finance, True Life, and what's the other one? These are all fund managers. I invested little sums of money for them to manage in which stocks they shall be invested. And as we all know, the prices of stocks fluctuate every now and then, especially during the pandemic. All of them are down, unfortunately.
Mm-hmm. Now, there were cash investments that you mentioned. What are these? Are you
These are the
referring
same. These are the same.
the same ones?
Yes,
Oh,
Your Honor.
okay. Now let's go to this very interesting matter subject, which concerns ABS-CBN.
Yes, Your Honor.
Okay. As we all know, ABS-CBN, the franchise expired last May 4, 2020.
Yes.
With the House of Representatives not approved or still pending with the application with it. Now, correspondingly and consequently, the NTC issued a cease and desist order. Majority of the senators then authored a bill to allow ABS-CBN to continue broadcasting until June 30, 2022. While some members of the House of Representatives are proposing for a joint resolution. Question 1. Is this joint resolution proposed by the House of Representatives a proper remedy?
No, Your Honor.
Why?
Because what is required is a law and not a mere resolution. As upheld by the Supreme Court, a resolution is a mere expression of the Congress's sentiments, or what they call now as senses. It's not a law. It did not pass through the procedure prescribed under the Constitution for the passage of a law.
Okay. Now, upon the other hand, granting that the senators are correct in proposing a bill, how will our equal protection of the law come into play, considering that it is not only ABS-CBN that will be involved? There are also other networks with the
Yes, Your
same
Honor.
status as the ABS-CBN.
That is
What is it?
that is a valid concern, Your Honor, because if they will do so without doing the same thing to those who are similarly situated, like ABS-CBN, there might be an issue on violation of equal protection of the law.
So with the proposal of, with the bill passed, filed in the Senate, it would be safe to say then that the equal protection of the law will not be secured.
If you are referring to their initial
Because, yes, because
intention to grant temporary,
for the ABS.
temporary, yes,
Uh-huh.
Your Honor. I believe so.
Okay. Justice Padilla, how
Yes, Your
effective are you as a leader? As a
Well,
presiding justice of your division, of
as-
your, yes.
As the
of it.
old cliche will go, I lead by example. So I tell my staff my demands and expectations. I expect them to be hardworking, to give their heart and mind in every task that will be assigned to them, that they be upright, honest, fair, and reasonable. And in order to inspire them to live up to these expectations, I myself do my best to exhibit those qualities, Your Honor.
And in the exhibition of those qualities, are you open to criticisms?
Yes, Your Honor. I am open, but I will see to it that my decision will not be influenced by criticisms. I can listen to them, read them, but at the end of the day, every decision must be decided strictly on the basis of its merits.
Were there times that you got stressed in the performance of your duty?
The adjudicatory function, I
Yes,
believe,
yes.
is inherently stressful, Your Honor.
And how do you cope with it?
Well, I'm already used to it. I'm already used to it. In times of high stress, I just turn to God for help and guidance.
Okay, I have here a couple of questions submitted by the Court Watch. And I just would like your opinion on this, your comments.
Yes, Your Honor.
The first question that it submitted was, what are your views on the constitutionality of the IATF resolutions when some of these issuances are contrary or may be contrary to memorandum orders of some administrative agencies? Just your point of view.
Well, while we are facing a pandemic, while we are in a very new situation, whatever regulations the IATF will promulgate, the same should still be cognizant of and respectful to the people's rights as guaranteed by the Constitution. The pandemic should not be an excuse to trample upon those constitutionally guaranteed rights, Your Honor.
Of course, when you applied for this position, you had in mind some reforms that you would like to initiate or introduce in the Supreme Court. Now, the next question would be, is the one submitted by this Court Watch.
Yes,
and this has something to do with, judicial reforms.
Judicial reforms.
Now, given the limitations to the operation of the courts during the COVID-19 pandemic, what are your suggestions on judicial reforms the Supreme Court should adopt, and how should access to justice issues be addressed?
I believe, Your Honor, that the Supreme Court has already adequately addressed the problem with its issuances allowing teleconferencing for cases which need urgent action, allowing electronic means of transmission for pleadings, papers, and other court submissions, and has already directed our trial courts to study, track down, and monitor all cases pending before them for the possible release of PDLs in order to avoid the spread of the virus in our detention facilities.
What are the other suggestions that you can give in so far as decongesting our jails are concerned, is concerned rather? How the Supreme Court can help in that?
Well, the
aside from the recent ones, which the PDLs were released upon serving their minimum penalty.
Oh, yes. But I would like to recall that provision in the rules wherein not only those who have served the imposable minimum imprisonment may be released on recognizance. There is also a provision there which says that those who have already served the imposable maximum period of imprisonment may already be released without even requiring bail or executing a recognizance. But this is, of course, subject to the continuation of trial. Then there are also provisions in the rules which say that executive judges are obliged to make a monthly report on their visitation of detention facilities. And among the objectives of this monthly visitation that they should undertake is to find out the prisoners, the identities of the prisoners, the cases that are pending against them, the duration of their detention for, again, possible release. Now, on top of these provisions in the rules of court, if I may add, the executive branch will also help to a great extent in the release of the said PDLs. Like, for example, I understand that the GCTA, or Good Conduct Time Allowance, is suspended. The Department of Justice may lift the suspension if it is already fine to lift it. Then the Department of Justice may also urge the Bureau of Pardon and Parole to find out who are those detainees who may already be released, as they are already qualified to be granted pardon or parole, so that the same will be submitted to the office of the President, who is vested with the power to grant executive clemency.
Okay, this will be my last question. Would the reimposition of the death penalty help in decongesting our jails?
I don't think so, Your Honor.
Explain.
During the time that we still had death penalty, I could not recall if there is any report to the effect that it has contributed to the decrease in the incidence of crimes.
That is correct, because as far as I can remember, it was only certain under the term of President Estrada,
yes,
that somebody was executed.
Yes, Your Honor.
Nobody else was executed before or after that, because of so many reprieves, so many legal questions, commutations. But I believe that if we just impose the death penalty, I believe that would help decongest our jails. Would you believe? Would you agree with on
as
that?
Deterrent, Your Honor, as deterrent.
Deterrent. Yes, as deterrent.
Yes,
Okay.
Your Honor.
Okay, Justice Padilla, that was my last question. And good luck.
Thank you, Your Honor.
Okay. Attorney Aricheta.
Thank you, Judge De Monteverde. The next to interview the candidate is the Honorable Justice Noel Jimenez Tiham. Justice Tiham,
Thank
sir.
you. Thank you,
Good
Attorney
morning, Your
Aricheta.
Honor.
Good noon,
Good
Justice
noon.
Padilla.
Yes, Your Honor. Good noon.
You're one of the brilliant magistrates in the Court of Appeals, so I will ask you the difficult questions.
That is not true, that I'm among the brilliant minds in the Court of Appeals. If that is your premise, Your Honor, for asking difficult questions.
Justice Padilla, correct me if I'm wrong. You belong to the Iglesia Ni Cristo religious organization?
Yes, Your Honor.
All right.
I
What
am a
would
member of
be
it.
if there's a case pending before you in the court, which to your mind would go against the interest of the Iglesia Ni Cristo? What would be your attitude towards that case?
It's really a case-to-case basis, Your Honor. Generally, I will not inhibit myself just because a party to it is the Iglesia Ni Cristo, or a member or an official of it is a party thereto, or one of the lawyers is a member of the Iglesia Ni Cristo. Because the Supreme Court has held that mere membership in a fraternity, in a social organization, and even in religious-oriented group does not automatically disqualify a judge from handling a case wherein a co-member of the said religious organization or his or her lawyer is involved. As a matter of fact, the Supreme Court even emphasized that members of good standing of these reputable organizations are even expected to deliver justice fairly, justly, and reasonably. So generally, I will not inhibit, Your Honor.
And you will have no hesitation, even if your decision will be adverse to the interest of the Iglesia Ni Cristo.
Our church, just like all churches, teach that we have to dispense justice on the merits without fear or favor. They will understand. I know they will understand, because that is also one of the basic principles, doctrines being taught to us members.
What do you understand by the concept of intellectual humility? What is your understanding of intellectual humility?
Not bragging about your being bright or smart or about your achievements academically, scholastically, just being in low profile.
In your job as a magistrate in the Court of Appeals, there might be cases that your decision might belong to the minority. In other words, if you are the ponente of a decision and there is a dissent, under the internal rules of the Court of Appeals, a division of 5 will be created.
Yes, sir.
If after the creation of the division of 5 and after due deliberation, you still find yourself in the minority, will you be willing to accept that you are wrong and that the majority decision is correct?
Well, it all depends, Your Honor. But the majority is not always right. If I think that my opinion on the matter is better, I will stand firm on it. But of course, will give due respect to the decision of the majority. I will not take it personally against me. It's all work. All will be maintained on professional level, Your Honor.
And you will comply with the decision of the majority, of course.
I will.
That is the meaning of intellectual humility. It is the ability to know, to admit, and accept that you might be wrong.
Yes, Your
All
Honor.
right. Now, the other question is, I'm looking for the difficult questions.
It's already
In a
lunchtime, Your Honor.
video conferencing like what we're having now, the Zoom meeting, last week, a man in Amityville, New York, United States, killed his father while his father was in a Zoom meeting. There were 12 participants logged in during such meeting, and they witnessed the crime. The son killed the father. This is factual. This is not a hypothetical case. If that crime happens in the Philippines, is that covered by Republic Act 10175, otherwise known as the Cybercrime Prevention Act of 2012? So there was a Zoom meeting. The father was a participant, just like one of us. And then suddenly the son of the father killed the father in full view of the participants in the Zoom meeting. Is there a cybercrime committed?
It's not a cyber crime, Your Honor. It's either murder or homicide, only that it was witnessed through Zoom.
So what do you mean by a cybercrime?
One committed through the cyberspace, but it was not done through cyberspace, Your Honor. He physically killed his father.
If somebody posts a threatening remark in Facebook, threatening the president, is that a cybercrime?
It depends upon the tenor of the threat, Your Honor. Like what we had recently, wherein the people offer sums of money. That's more of inciting to sedition, I believe, Your Honor.
All right. Now, let's talk about China. Have you been to China, Justice?
Yes, Your Honor,
All
before
right.
the pandemic.
The COVID-19 pandemic severely affected the political, economic, and social orders in many countries worldwide. And this disruption raised certain voices in the US and in Europe calling for China to be made legally accountable for their losses. In the Philippines, can an individual who feels aggrieved by the pandemic and who believes that the pandemic was caused by the so-called Chinese virus, can he file an action against China to claim damages by arguing that China deliberately withheld information and failed to contain the virus?
Your Honor, please, I believe that China should be held liable. But it's really a big question how to make China liable. Under
Can the complainant file a complaint before the national court, a domestic court?
I don't think so, Your Honor. He will be suing a sovereign state, and we have the doctrine on non-suability of sovereign states.
Can the complainant file a lawsuit against China before the International Court of Justice?
If Your Honor, please, under the international health regulations to which China is a signatory, every signatory state is obliged to give timely, adequate, and accurate information regarding infectious diseases, especially a new one. But then, the same treaty provides that while there may be reparations for damages that may be demanded from a responsible state signatory, the same can be had only with the consent of the concerned sovereign state. Even under the whole Constitution, while it allows the filing of a case before the International Court of Justice, again, the consent of the state must be sought. And our experience on UNCLOS taught us this is most unlikely that we will be able to get the consent of China. So maybe
So a Filipino who files a complaint before the International Court of Justice, that suit you think will not prosper.
yes, Your Honor, for the same reason I just cited.
What about the International Criminal Court? If a lawsuit is filed against China before the International Criminal Court, will it prosper?
Before the International Court of Justice, the crimes covered are like crimes against humanity, genocide. If it will fall under any of the crimes falling within the jurisdiction of the said court, Your Honor, he may. But again, whether or not it will prosper in the sense that he will be able to actually claim damages is another question.
A Filipino filed lawsuit against China before the International Criminal Court, but the Philippines has already withdrawn from the International Criminal Court, correct?
Yes, right. I
And
remember.
China has never ratified the Rome Statute, so that lawsuit will not prosper also.
Yes, because we had already withdrew from the Rome Statute, which provided for the creation of the International Criminal Court of Justice, Your Honor.
What about the complaint by a Filipino against China due to the pandemic before the United Nations Security Council? Will it prosper?
An individual, I think only as a co-state may file such an action, Your Honor.
So it will not.
It will not.
It will not
I believe
prosper.
so, Your Honor.
All right. What do you understand, Justice Press, of police power of the state?
It is the power of the state to issue regulations, laws, as may be necessary in order to protect its people's safety, welfare, and interests.
Which branch of government exercises police power of the state?
Basically, it lies in the Legislative Assembly, as it is the one vested with the power to legislate.
So the police power is not the power of the police. That's different, correct?
It is not, Your Honor.
All right. My last question is, because of the lockdown and quarantine worldwide, many people violated protocols. Many people became hungry because they were faced with the lack of immediate and essential need for nourishment. If hungry citizens, hypothetically, steal small amount of food to stave off their hunger, is it a crime?
It is, Your Honor. That
It is
is
a
not
crime.
among the exempting circumstances provided for under the revised penal code.
An Italian court recently ruled that theft of food is not a crime if the perpetrator is hungry. The Italian highest court of appeal ruled and overturned a theft conviction after the perpetrator stole cheese and sausages. The Italian court said stealing small quantities of food to satisfy a vital need for food did not constitute a crime. Is the defense of a hungry stomach not a valid defense under Philippine courts?
Under our law, it is not, Your Honor.
It
I
is
believe
not.
there is no, yes, until now.
And finally, what's the difference between IQ and EQ?
IQ refers to
It
intelligence.
it has nothing to do with quarantine. With quarantine,
with
okay?
ECQ and
IQ
CQ.
and EQ, okay. What's the difference?
IQ refers to intelligence, to one's intellectual capacity. EQ refers to emotional quotient, more on the how a person will emotionally deal with a problem
For a
in
magistrate,
every situation. Yes, Your Honor.
for a magistrate, which is more important, IQ or EQ?
It's both, Your Honor.
Which
They
is
should
more
go together.
important? Which is more paramount, IQ or EQ? And in other words, hypothetically, for the members of the Judicial and Bar Council, which one should be more important in evaluating a magistrate? Is it the IQ or the EQ?
I insist it should be 50-50, Your Honor.
What about, have you heard about AQ? Adversity quotient. Have you heard about it?
Only now, Your Honor.
Only now. It is the ability to cope with difficulties,
Yes,
with
adversities,
problems.
yes.
So do you have IQ? You have IQ? Do you have EQ, Justice Pressing?
I believe so, Your Honor. All the
Do you have-
Qs you mentioned, Your Honor.
And AQ also.
Yes, Your Honor.
All right. Thank you and good luck.
Thank you, Your Honor.
Thank you, Justice Tiham. The next interview will be the Honorable Judge to review Ilaw Jr. Judge Ilaw. Judge Ilaw, sir, it's your turn.
Yes, thank you. Thank you, Tony Archeta. Yes, good afternoon, all the members.
Good afternoon, Your Honor.
Yes, good afternoon, Justice Padilla.
Yes, Your Honor.
So this is the first time you're applying Supreme Court Associate Justice.
You're right, Your Honor.
Can you tell me something about yourself that is not found in your application requirements?
I am a hardworking individual, Your Honor. Consistently hardworking. And I think that is one of the qualities that is needed in our judiciary, aside from the others that I have mentioned already in my PDS.
And what inspired you to apply for the said position?
I have been in the judiciary since 1996, and I think it is the dream of every magistrate to reach the highest court of the land. That is the pinnacle of their judicial career.
And if appointed, what do you believe will be your most contribution to the Supreme Court?
Well, I would like to be part of the Committee on Rules of Procedure because I have been teaching remedial law for a number of years. So I think I can contribute to the further improvement of the said rules. And of course, I will try to do my best to come up with well-written, well-researched decisions, considering that the Supreme Court is the court of last resort. The adverse party cannot make an appeal or to any other body.
And how do you view the credibility of the Supreme Court?
For now, I believe it has the support of the public. The public has trust in the workings and also in the integrity of its individual members.
Do you believe that there is corruption in the judiciary?
Well, I have heard some stories, but I don't know if they are true, Your Honor. But by and large, with my stay in the judiciary since 1996 up to this date, I believe that the vast majority of our judges and magistrates are upright and honest.
Yeah, a while ago, when asked about your stint as the Court of Appeal Associate Justice in the Court of Appeals based in Cebu, with
Yes, Your Honor.
respect to the investigation in alleged justice for sale filed by a certain Thelma Chong, what then has been the progress of this case? What's the status?
I think actually it's a letter request. It has not ripened into any administrative action, Your Honor. But it ended up with the Supreme Court in order to protect the integrity, the dignity of the said station and of the judiciary as a whole, had came up with a resolution providing that waivers are no longer allowed when it's already time for the magistrates in the said station to move to other places, particularly to Metro Manila. They should do so. They cannot waive anymore. So as a result thereof, those who have stayed in the Court of Appeals, CA Cebu Station for long, have been moved to Manila. And I was one of those who remained in the said station.
All right, let's see about your judicial philosophy. How do you view the doctrine of stare decisis?
Stare decisis. It refers to the doctrine providing for adherence to judicial precedents, that when a case involving an issue has already been resolved with finality in a previous case and another case crop up involving the same issue, the said case must be decided in a similar way. This gives rise to jurisprudence, which is needed for the stability of our court processes.
And has been raised by the court appointments during, it was last year, by December 18, 2019. Do you agree with this statement? The court, as the highest court of the land, may be guided, but is not controlled by precedent.
Yes, Your Honor, being the highest court of the land, whatever jurisprudential doctrines that are now existing, the Supreme Court en banc may reverse or supersede the same whenever there are compelling reasons.
Because this was part of the Supreme Court's ruling in the 2010 case, De Castro versus the Judicial and Bar Council and Macapagal Arroyo, GR number 191002. Would you believe, do you agree with the statement that if you are in the highest court, never mind precedents?
No, Your Honor. We still have to consider precedents. As you pointed out, these are among our guideposts. And that is needed, Your Honor, because that will give rise to jurisprudential doctrines. So we don't have to relitigate the same issues or similar issues. This is necessary to promote stability in the judicial system. Although these are not all controlling at all times. It's really a judgment call on the part of the Supreme Court, whether or not to adopt the said precedents or deviate therefrom to give rise to new doctrines.
About the sense of creativity?
Creativity?
Must be productive, progressive,
yes.
Always attuned to the times.
Yes, the decisions of the Supreme Court must also be made responsive to the needs, the call, the changes of the modern times.
And what are the challenges in automating court processes? And how will the court ensure that automation programs in the judiciary will be effective considering possible roadblocks?
I think we haven't achieved fully automation, Your Honor, especially in the trial courts, insofar as their proceedings are concerned. But it will be best if we could automate the proceedings below, because I believe this will help in a more expeditious disposition of cases, especially with the requirements on continuous trial, not only in criminal cases, but in civil cases as well. They may be challenges, Your Honor, like those who are not uh, electronically equipped. There is also a challenge in the budget that is needed to effectuate automation. That is it, Your Honor.
By the way, what is judicial temperament?
Judicial temperament. This refers to a judge's attitude towards lawyers, litigants, law, and co-judges, Your Honor.
How about the doctrine of judicial restraint?
Judicial restraint is one wherein the court limits its power by, for example, holding the constitutionality of laws unless they are patently constitutional. It is where a judge does not venture into interjecting in his decision some of his policy preferences and leaving the same to the legislative body, which has the mandate of the people.
All right. Browsing your PDS, your daughter is an executive assistant 2 in your office,
That is right, Your
while your
Honor.
niece is executive assistant. While your niece is executive assistant 6,
Right, Your
and
Honor.
son-in-law executive assistant 4.
Right,
Why
Your
not
Honor.
give the highest position to your daughter?
Because my private secretary, my niece, has been there already for long. So she's already familiar with all the tasks pertinent to her position. And my daughter herself doesn't want that I remove her cousin, who is her best friend actually, to give way to her.
So you are also one of the justices in the Court of Appeals having relatives.
Yes, Your Honor. Anyway,
Relatives incorporated.
I will admit, Your Honor, because they are the people I trust. They are the people who know my do's and don'ts. They know also the work ethic that they should observe. Anyway, Your Honor, I just recommended them, and fortunately, the Supreme Court approved the recommendations.
About your husband, an intention of joining the Court of Appeals?
None, Your Honor. He's enjoying his private legal practice.
Private legal practice.
Yes, Your Honor.
Also extra legal practice.
I have to ask him that, Your Honor.
Okay. All right, let's go to jurisprudence again. What does the Supreme Court have to say with regard to pre-approved credit cards?
Pre-approved credit card.
Are these still prevalent nowadays?
I think so, Your Honor. Because banks are checking on the credit standing of depositors, of people. And I think they have a pool of information regarding the same. And when they find that some are in good standing, they themselves will offer their credit cards without the persons going through the regular application process. They're still prevalent, I believe so, Your Honor.
Have you read the case of People versus Spouses Sarda, GR number 239-092, was penned by Justice Alex Gesmundo?
Unfortunately, not, Your Honor.
Let's go to the more recent case. What is your take on the case penned by Justice Reyes with respect to the constitutionality of the FILSAT?
I think it was struck down as unconstitutional, and I believe so, Your Honor, because it infringes the school's academic freedom. Because the law schools have the freedom to choose who are to admit. But with FILSAT, they have to go through the said examination and pass the same in order to be eligible for enrollment in law schools. Also, FILSAT requires, I think, legal internship or apprenticeship, and this also violates the school's academic freedom, as the school has the freedom to determine what to teach.
So giving stress to such, it must be consistent with academic freedom and the right to education.
Yes, Your Honor.
And some provisions had been declared unconstitutional, while others provisions were considered constitutional. With respect to the imposition of 53, passing scores usurps the right and duty of the school to determine for itself the criteria for admission of students, and taking thereof within 2 years as prerequisite for the admission to any law school. Don't you think that this route counters, directly counter to institutional academic freedom?
I'm sorry, Your Honor, you're not clear.
Have you read thoroughly the decision?
Not really, Your Honor.
Do you agree with me that there are so many questions, there are so many answers brought by that case?
I was not able really to read the entire text, Your Honor.
All right, let's go to some psychological, critical thinking questions. Pretend that you are a Chief Justice. What three concerns about the judiciary would you keep up at night, and what would you do about them?
I will, I think among the top concerns are promoting a more expeditious disposition of cases, addressing the problem on corruption, and automation of the entire judiciary and its proceedings.
And mention about corruption. What measures would you propose to minimize, if not to eliminate that problem?
I think there should be a holistic approach to this, starting off with producing ethical lawyers, because it is from there that ethical judges and magistrates will emanate. So from the very start, from the time that students enrolled in the law school, emphasis must already be made on legal ethics in their orientation. And I think law professors should be encouraged to interject in their lectures every now and then nuggets of legal ethics. And this should be done consistently until they pass the bar exam. Another is to encourage people who have complaints about corruption to come out in the open, name the justices or judges being complained of, so that those who are really guilty may be held liable. This will also serve as deterrent against commission of the same unlawful acts. Third, maybe, well, one time I read in an article that in Singapore, their highest paid employees are those working in the government. And one of the reasons given is to make the government workers less tempted to bribes and offer of similar considerations.
And what will be the last concern if you were to be appointed as a Chief Justice? You mentioned about two concerns.
Automation, Your Honor. The automation of the entire
You already
judiciary.
mentioned automation.
Yes. Speedy justice. There are already three, Your Honor. Speedy justice, corruption, and automation.
All right, then. Do you have any regrets?
Regrets. What I could recall now is that I regret having appointed to the second highest court of the land when my both parents were already gone. Actually, it's my father who prodded me to take up law. It's not in my dream. It's not in my plan. I just wanted to be a simple and plain teacher.
Your father's already deceased.
Yes, my mother as well.
Okay. All right, my last question will be like this. You are a new addition to the client box. What color would you be and why?
I'm wearing my favorite color, Your Honor, green.
Green.
Yes.
Why? Why did you choose green?
It's cool to the eyes. It's cool to the eyes. It represents nature, and I love nature. Everybody loves nature. Nature is the best evidence that there is God. That's it, Your Honor. I want to be close to God, to nature.
Thank you. That was my last and final question. And good luck, Justice Padilla.
Thank you, Your Honor.
Yes, Tony Archeta, Chief Justice, members. I'm done.
Tony Archeta. Tony Archeta.
Attorney Ed.
Yes.
Thank you, Judge.
Attorney Ed. Oh. We cannot hear you. Unmute.
Thank you, Judge Mendoza. Justice Mendoza, sir.
Yes, yes. I can hear you. I can hear you.
Yes.
Is it now my turn? Because the audio is not very clear from your end.
Yes, sir.
Can I start now? Can I start now?
Yes, sir.
Morning, Justice Padilla. Is it already?
Good afternoon already, Your Honor.
Already.
Yes, Your Honor. Good afternoon.
Can you still?
Yes, sir. Yes, Justice Mendoza, sir.
Yes. Justice Padilla.
Yes, Your Honor.
You have impressive credentials. You have been valedictorian in the elementary level and also high school level and graduated magna cum laude from Lyceum and landing 5th in the bar. And you rose through the ranks. and you have also a good reputation.
Thank you, Your Honor.
What do you think are your weaknesses? First, nobody's perfect.
Yes. I think my weakness is that I want all things done as fast as possible. I don't want papers piling up on my table. And I think it's a weakness because I still continue to be so, even if it's already causing me so much stress and sometimes to the detriment of my health.
You were asked by Judge de Monteverde about your health, particularly the aorta. Did you not look it up?
I
Your
did not
condition?
because I'm not feeling anything bad at all about my heart, Your Honor.
Oh, because you said you have been leading a stressful life. Yeah, our career is really stressful.
Yeah, that's it.
You
I'm
should
able
have,
to cope
you
with
have,
it.
you check. You see your doctor and check that
Yes, Your
because I'm
Honor,
a
I will.
bypass patient. Oh, my and also angioplasty, my aorta, three were blocked. So you better have yours checked. It is not a disqualification.
Thank you, Your Honor. I will take your advice.
And then I heard you, maybe I heard you right. You want the trial to be automated. Am I correct there?
Yes, Your Honor.
Oh. And are you computer literate?
I am not fully computer literate. I always ask assistance from my daughter, from my son-in-law. I have to admit that. But I think automation will really help a lot because when I was a trial court judge, Your Honor, the problem really is on the timely transcription of the court proceedings.
Yes.
And even if then I already had 4 stenographers, still not enough. So what I did then to cope up with the deadlines I set for myself is to borrow their tapes.
Yes.
I played those tapes, but it's really very difficult because you
it's
have to
really
rewind,
difficult.
to move forward and all.
You should have borrowed their transcript and correct your decisions to the transcript.
Yes,
I
Your
asked that
Honor. I
because
do that only when the transcripts were not yet available and it's nearing the deadline I set for myself.
because you can summarize the testimonies through the TSN of your stenographers.
Right,
You
Your
can do
Honor.
that
But
in 1 day.
unfortunately, they were not able to cope up with the phase of work in our office at that time.
I see. I asked this because I had a hard time reading your what you wrote yesterday. It
Really?
was handwritten.
It was.
Because I could not.
Oh, that's unfortunate.
I could not do a speed reading because it was handwritten.
Sorry,
So
Your Honor.
maybe I thought you were not computer literate. So at this time you are not computer literate.
To some extent,
No.
yes.
So you are
To
not.
a large extent, no.
Did you agree that justices should also study computer?
Yes, with my experience lately, Your Honor, yes.
So,
I will start doing that, Your Honor.
yes, and you edit the drafts also in your computer. That will make your decision making faster.
Yes.
And
Only that, Your Honor, I really have problems scrolling up and down because of my eyes.
yes,
And because I have vertigo, I get dizzy after a while.
So you can dispose of your cases faster because it appears from your record here. I'm not sure this is accurate. You still have how many pending cases?
270, Your Honor.
270.
I think as of February.
I see.
This is can be attributed as well the spike because there are still many vacant positions in the Court of Appeals. So cases were raffled off among fewer justices. So each justice has an increase in his or her caseload because of that. We have, I think, before more than 10 vacancies. more or less.
Now vacancies. Okay, there were questions earlier. You mentioned that you were the examiner last year or 2 years ago. I'm not sure.
No, just last
Sibilo,
year, just yeah,
Sibilo,
part 1 only.
part of 7 Sibilo.
Part
This
1
I
only.
asked already before. I do not know if you have been asked. This is a pending case in the Supreme Court. What is the Iron Curtain rule in succession?
The Iron Curtain rule says that an illegitimate child cannot inherit from the legitimate children and relatives of his or her father or mother.
Okay. That is a case pending in the Supreme Court. I do not know if it has already been disposed.
I don't think so.
So,
The Aquino
Do
case, Your Honor.
what is your opinion? Is that law fair or it needs to be amended?
Well, some are saying it is unfair, especially in the light of that case you are mentioning, Your Honor,
Yes.
where the facts are very peculiar. I think if ever the same should be modified, that should be left to Congress to do, Your Honor. Because I believe that will involve policy formulation. So that in the hearings that will be conducted by Congress, all stakeholders or all those who may be affected by the said provision will be duly heard.
The issue of its constitutionality was raised in that case. I think you're familiar with that case. Can the Supreme Court resolve the issue of constitutionality of that case?
That Iron Curtain rule, Your Honor?
Yes. Because you said it should be amended by Congress, but the matter was raised in the Supreme Court, and its constitutionality was questioned because it violates, for one, the Equal Protection Clause. Or can the Supreme Court rule on its constitutionality?
I believe so. It's the call of the Supreme Court. If the
It's called
Supreme
the
Court,
Court.
yes, will opt to exercise judicial activism, then it may do so. Especially with the changes that have taken place since the passage of that law. It may, if constitutional issues are raised, and the Supreme Court is vested with judicial power to decide on constitutionality of an official act.
Yes. Oh. What is your view on online trial of criminal cases?
I think that will be fine. It is okay to have online trial of cases, especially in our present situation.
The right of the accused to confront the witnesses against him face to face?
I think we have this TV link kind of taking the testimony of a minor victim of a child, and that is allowed by the Supreme Court. And I think the right of an accused to confront his or her witnesses face to face is not violated because he or she, the accused, can still do so through
The constitutional
the modern technology.
requirement is satisfied.
Yes, because I believe that the rationale behind this right to confront witnesses face to face is to afford the accused the opportunity to cross-examine his or her witnesses, and also to give the court the opportunity to observe the demeanor of the witness while testifying, because this may be one of the criteria the judge will consider in weighing the testimony of the witness. And all of these can be still sufficiently achieved through teleconferencing.
Earlier, you covered the Rome Statute that the Philippines has already drawn
Yes, Your Honor.
from the Rome Statute. What is your view on the acts committed before the withdrawal? Can the body continue investigating a person under indictment?
I think so, Your Honor, before the withdrawal. So before the withdrawal, we're still bound by the said treaty.
You were able to listen to the question earlier I propounded to Justice Bato.
Yes, Your Honor.
Yes. I covered in the PDS of the JBC, you are required to execute a waiver so the JBC can examine your finances and other submissions.
Yes, Your Honor.
Do you have any objection to that?
No, Your Honor, because waiver is personal. So for as long as that person is willing to execute the waiver, no force, violence, threat, or intimidation is employed on him, then that will be valid. It's his or her personal right that is at stake. It's really his or her call to comply with the requirement on waiver or not.
This is now with respect to the firearms law. Justice Bato opined that if a gun owner is required to sign a waiver or waives his right to be searched, the authorities can search the premises if he applies. Because under the firearms law, it is required that you sign a waiver to enable the authorities to inspect the premises. Is that requirement constitutional?
I don't think so, Your Honor. I don't know how it is connected with the application for gun that one's premises must first be searched without a warrant, that is. So that, I think, will be violation.
Suppose the compelling state interest is national security.
Even then, Your Honor, we have to give primacy to a person's constitutional right to be secure in his house, unless there is a consented search through a waiver.
You agree with Justice Bato that if you waive, they can inspect?
Yes, Your Honor, that is a recognized exception against searches without
really,
a warrant.
If it is against your will, but it is a requirement, can you be forced to execute the waiver?
No, Your Honor. You just have to face the consequences that you will not be given permit if you are not willing to comply with the requirements. You are not really forced. It's really, the choice is still there with you, whether to apply or not to apply, because it's a mere
You have read the
privilege.
case of Acosta versus Ochoa regarding constitutionality of that requirement?
Unfortunately, Your Honor.
That was just last October.
I'm sorry, Your Honor. I was then very busy checking the bar exam booklets.
Bar exam, But you must have read the case of Saluday versus people. You teach remedial law,
Yeah, but I'm now on
criminal procedure,
no civil.
civil procedure.
Yes, Your Honor.
Yes. So anyway, you can easily answer this.
Yeah, I hope so, Your Honor.
In Saluday, the court made a distinction between a reasonable search from a warrantless search. What is the distinction between the two? What is a reasonable search?
And
What is a warrantless search? You
Okay.
distinguish one from the other. Both have no warrants. It was written by Justice Carpio. It's a 2018 case. So it was before you corrected, you were correcting the bar examination.
Yes, but unfortunately, I was not able to read that decision as well.
Oh.
But anyway, may I just have my
your best guess. Distinction between a reasonable search and a warrantless search, and give examples of each, so you can amplify your distinction.
maybe warrantless arrest refers to those instances.
Do not proceed it with maybe.
But this is
Okay.
a guess, Your Honor. I have to admit.
Sige.
Warrantless search may be referring to those instances which are already recognized exceptions to instances where search may be made without a warrant. Reasonable search may be not among those, but for as long as the same is founded on probable cause and it is not that intrusive, then that may be justified also as an exception. That is my guess, Your Honor.
Regarding your reasonable search, can you give examples? What is really the essence? What the difference between the two? Essential difference.
I'm sorry, Your Honor, I have not read the decision, so this is the first time I have to admit I have heard about them.
Oh, you read Salude versus
Yes, I will, Your Honor.
April 2018.
2018, yes, Your Honor.
You teach also political law?
No, I don't.
No, political science.
Oh, that was long
But
time
you
ago.
constitutional law. Constitutional law.
I haven't taught it.
But you have an idea of what is the right to privacy?
It is the right not to be interfered with by other persons insofar as my personal life, home, correspondences, communications are concerned.
How do you reconcile the Freedom from Information Act with the Privacy Act?
The freedom of information gives the people the right to access to information on matters of public concern, Your Honor. It should not interfere and be violative of one's right to privacy.
What is covered by the right to privacy?
My personal life, personal effects, personal
Yes.
correspondences, communications.
How about public officers, public officials?
Well, just like other ordinary individuals, they also enjoy the right to privacy insofar as their private matters are, insofar as private matters are concerned, but not with respect to the discharge of their public functions.
During this pandemic, it was to find that the names of those affected by the COVID-19 should not be disclosed because it violates their right to privacy. But the state has interest in knowing who have been affected so they can be traced and uh, mitigate the effect or the possibility of it being transmitted. Do you agree with that opinion that the names of those affected should not be disclosed?
Well, Your Honor, in the interest of public health, safety, and welfare, this right should take a backseat. So
the name should be
maybe
can be
disclosed for
Can be
contact
disclosed.
tracing and for
Contact
all other
tracing.
measures to contain the spread of the disease. That is a
So
valid
that
exercise of
so
police
that
power.
other persons who are not aware
Yes,
that they have been in contact with him will take measures to protect his or her health,
that is right, Your
their
Honor.
health. This has been this is also jurisprudence, but this is uh, I'm not aware of any Philippine case yet. But what is a third party doctrine case?
Third party,
Doctrine. What is that legal principle?
maybe it has something to do with contracts. So third party,
In US
yes.
versus Miller, it was defined as a legal principle that when an individual voluntarily gives information to a third party, the privacy interest in that information is forfeited. But we will not go into that because you have not read it. Justice, one of the issues raised against PDR is that it ABS-CBN is that it violated the constitutional provision on ownership. It was alleged that ABS-CBN took advantage of the PDRs to violate this. What are PDRs?
Philippine Deposit Receipts,
Yes, yes.
whereby corporations who issued these receipts are able to get investments, huge investments from foreign corporations, foreign sources.
Yes.
And the holders of these PDRs become entitled to a share in the dividends that may be declared by the issuing corporations. I think these PDRs have all the attributes of ownership, like possession.
Okay, excuse me. Can you repeat it? Naghang. So sorry.
The holders of the PDRs are entitled to have a share in the dividends that may be declared by the issuing corporations. And I think they have all the attributes of ownership, just like holders of shares of stocks. That's why it is an issue, even a constitutional one, that is raised against ABS-CBN because of the constitutional prohibition against foreign ownership and management of mass media.
It was opined that the sale of PDRs are only sales of securities, not ownership. What is your view?
But through these PDRs, Your Honor, this is just my
Yes. Your opinion
an
only.
opinion.
I will not take it against you. Whatever your,
But through
just know how you reason out.
Yes, through these PDRs, foreign corporations were able to invest huge sums of money. And I think that alone would give them some sort of control over the management of the issuing corporations, Your Honor.
So you mentioned control. So that would be violative, an instrument that can be used to violate the constitutional provision.
Yes, it may be used for that purpose, Your Honor.
For that purpose. Thank you very much, Justice Padilla. I think you're hungry already.
Yes, I
The
am.
best of luck.
I
Thank
thank you
you
too,
very
Your
much.
Honor. Thank you.
Si Justice, Chief Justice pa pala.
Opo.
Thank you.
Good afternoon po, Chief Justice.
Thank you, Justice.
Yun.
Honorable Congressman.
There's technical problem.
Diretso na si Chief. Tonile.
Yes, Attorney Ed, his bandwidth is low. So, Mr. Chief Justice, may we proceed
Okay.
with the Honorable Justice Veloso?
Justice Congressman Veloso will be ahead of me.
Yes, Mr. Chief Justice, sir.
Nandyan si
Justice Veloso.
Congressman Veloso.
Yes.
Good afternoon, Congressman.
Good afternoon, Justice.
Lumitaw siya kanina. So,
Uh,
okay. Congressman Veloso, sir.
so, can I start? Hello, can you hear me?
Yes, sir. It's your turn.
Okay.
Congressman Veloso,
Can you
sir.
can you hear
You
me?
may now proceed.
Okay, can you hear me?
Yes, Your Honor.
Okay.
Justice Veloso, sir, you may now.
Okay.
Yes, sir.
Okay. You've got a very good credential,
Thank you, Your Honor.
both as a judge and both as a student, a judge, and a magistrate, justice of the Court of Appeals.
Thank you, Your Honor.
What is your caseload now, by the way?
Your Honor, again, please. There's technical problem.
What is your caseload now?
Caseload. As of February, Your Honor, it's 270. Those for completion, Your Honor, but 0 insofar as cases submitted for decision.
Okay, so that's good.
Thank you, Your Honor.
My question will center now on ABS-CBN.
Yes, Your Honor.
A while ago, I think it was Justice Bato who said that despite the fact that the jurisdiction, the powers of both Congress versus the Supreme Court have been defined in Article 8 of the Constitution. I'm looking at Section 2 in relation to power of Congress to define jurisdiction and the power of the Supreme Court in relation to procedure. He said that this can be expanded by the rulemaking power of the Supreme Court. For example, instead of confining a petition for certiorari jurisdiction-wise only to grave abuse of discretion or jurisdictional errors committed by a judicial or quasi-judicial body, he said the expanded jurisdiction now says that even acts of Congress can already be inquired into or reviewed by the Supreme Court. What is your view on this?
The judicial power of the Supreme Court as defined in the Constitution includes the power not only to settle controversies involving legally demandable and enforceable rights, but also the power to determine whether or not there is a grave abuse of discretion on the part of any branch or instrumentality of the government, which includes the political branches, like the Legislative Assembly, Your Honor.
Where is that in our rules of court?
No, Your Honor, it's in the Constitution, in the definition of judicial power. It does not actually say the political branches. What the Constitution refers to is grave abuse of discretion on the part of any branch or instrumentality of the government. That has been interpreted to mean to include political branches, Your Honor.
Yeah, but certiorari, in my understanding, refers only to jurisdictional errors committed by quasi-judicial bodies, judicial and quasi-judicial bodies. While in that's Section 1 and Section 2, it refers to prohibition. It can be ministerial, committed by both judicial, quasi-judicial, and ministerial functions of any agency. Now, mandamus, it refers to neglect. Mandamus could be the core of the issue now because Congress failed to act favorably on the petition, on the application of ABS-CBN for a franchise. So, by what rule or window of procedural jurisdiction should ABS-CBN go into?
Against whom, Your Honor? Against Congress?
Against Congress.
I could not think of any, Your Honor, because the grant of franchise, while it is true, is exclusively vested in Congress, Congress cannot be compelled to issue such to any entity because franchise is a mere privilege. It cannot be demanded as a matter of right, therefore cannot be compelled by mandamus.
Are you aware of an action filed by ABS-CBN against the government, which is now pending before the Supreme Court?
What I know is the petition for certiorari the ABS-CBN has filed against the National Telecommunications Commission involving the cease and desist order that it issued, Your Honor, on after the expiration of its franchise on May 4.
So, again, going back to the conflict of jurisdiction versus procedure, because you would note that under Section 2, Article 8 of the Constitution, it says that Congress shall have the power to define, prescribe, and also the jurisdiction of various courts.
Yes,
but
Your
it
Honor.
may not deprive the Supreme Court of its jurisdiction enumerated in Section 5. And in Section 5, Paragraph 5, it refers, among others, to procedure. That's why when in Congress a question is being asked of me, would this be unconstitutional? Would this bill be unconstitutional? I said, when it comes to procedure, give it to the Supreme Court. when it comes to jurisdiction, pwede tayo makialam dyan. Am I
I
correct?
agree, Your Honor. I agree, Your Honor. I agree.
Okay. Next is the issue of franchise.
Yes, Your Honor.
ABS-CBN is asking Congress that that a new franchise be issued. Okay.
Yes,
Question is, they are asking for another 25 years, despite the fact that they already have 53 years. That was the explanation by Congressman Marcoleta. What can you say about that?
If it already exceeded 50 years, that is the limit set by the Constitution for the grant of franchise, Your Honor. For the first, maybe for 25 years, but renewable only for another 25 years. That is what I could recall, Your Honor.
A question was raised. There is no provision in the Constitution empowering Congress to issue or revoke franchise for television mass media. Do you agree with that?
In the Constitution itself, Your Honor?
Yes.
That is also my impression, Your Honor.
There is, or there is none.
I haven't found any as of this moment.
Well,
up to this moment. But by jurisprudence, Your Honor, it has been so held.
Of course, I defended the position of Congress here, citing Article 12, Section 11, that
Public utilities.
franchise, certificate, authority to operate a public utility.
Yes, that is it. That is what is provided, Your Honor, in the Constitution.
Okay, but the debate now is public utility, according to some quarters, is different from a public service entity. Do you agree with that?
Well, there is an argument to that effect, Your Honor.
Yeah, but do you agree with that position that public utility is different from public service?
I think a public utility is engaged in rendering public service, Your Honor.
Yes, of course, in my research, when you talk about public service and public utility, you have to refer to Act 3316, December 4, 1926, because there, Congress said that public service and public utility can be interchanged. And two requirements required. One is an entity is rendering public service for compensation. That's the second point. My question is, are you aware of the doctrine of contemporaneous contemporaneous legislation?
I'm sorry, Your Honor, I'm not.
Doctrine of contemporaneous legislation.
Contemporaneous.
As a student, I was informed then that the doc refers to statutory construction. When a law is to be interpreted, it has to be interpreted in the understanding of what the law was at the time it was passed. Now, Article 12, Section 11 used public utility. So therefore, in my view, it should be interpreted to mean also an entity that is engaged in public service for compensation. Do you agree with me on that?
Yes, Your Honor, because they still render public service. I think that's one of the principal factors to be considered.
Some of my colleagues told me to ask you magistrates about their observation. ABS-CBN has been closed by virtue of cease and desist order of NTC, National Telecommunications Commission. Yet they have ANC, they have four other channels which airs the TV Patrol, for example. This is not, I have nothing to do with ABS-CBN. Pinapatanong lang po ito. What can you say about that, especially that we talk about Article 8, paragraph. The judicial power of the Supreme Court refers to actual controversies involving rights which are legally demandable and enforceable. How can you demand something that you are already enjoying? Meaning, ABS-CBN was closed, Channel 2 was closed, but ABS-CBN has other channels like ANC, all the stuff. What can you say about this?
Maybe, Your Honor, the ABS-CBN is able to operate through other platforms because those platforms are not covered by the cease and desist order issued by the NTC.
But the question again boils down to one thing. By what authority of law can ABS-CBN operate those other channels? Can NTC just issue a certificate of authority without a franchise issued in favor of those other channels?
No, Your Honor. Franchise should first be granted because NTC is a mere regulatory agency. Therefore, it may come in only to regulate once a franchise has been granted.
Okay, another question that my colleagues insisted from me to ask you magistrates, very brilliant people in this world, is that congressmen differentiated from the Senate are representatives of the people. They are elected per district. Okay?
Yes,
And
Your
that's
Honor.
why our title is not congressman but representative.
Right.
Now, the principal function we have as representatives of the people is to see to it that all programs of the government that would be material to our particular districts should be covered by a budget. And what is your understanding about the General Appropriations Act?
Come again, what is it, Your Honor? I cannot hear.
What's your understanding about the General Appropriations Act, which yearly Congress passes into law?
What I know is that congressmen were the power of the congressman to allocate some funds for certain programs for beneficial to their constituents has already been removed, Your Honor. So all
Okay.
items now should be listed in the General Appropriation Act.
The bottom line, Justice, is this. Under Section 29, Article 6 of the Constitution, there is a provision which says that no money shall be paid out of the Treasury except in pursuance and of appropriation made by law.
Yes, Your Honor.
Okay. Time and again, it comes out in the papers bago ng COVID-19 as well as in media that congressmen fight for infrastructure projects in their respective districts. They are being labeled as crocodiles quarreling over pork. What is your understanding of a pork barrel?
What I understand about this is that a certain amount is allocated for each congressman, and this is for the projects that such congressman might want to implement later on for the benefit of his or her constituents. So whatever programs he may decide to subsequently allocate funds out of that amount given to him or her individually are not yet named or are not yet listed in the General Appropriation Act.
Okay.
It is as if they are now the discretionary power for them to determine to which programs or projects the funds has already been removed.
Okay. Actually, if you take, I took a look at the definition of pork barrel from Encyclopedia and Webster's. It says that pork barrel is an appropriation for government projects or expenditures in the Appropriations Act. And pork barrel, by definition in the dictionary, is not bad. But you have a decision. This is penned by Justice Del, which says that pork barrel is bad. Uh, any opinion from your end?
Actually, pork barrel itself is not bad. It is only sometimes when the same is already tainted with corruption, so they say, like in the Napoles case, that the same became bad.
Mm-hmm.
So it really depends on the individual congressman involved as how to make intelligent use of the said fund.
Actually, it is not Congress who implements the General Appropriations Act. It is either the judiciary or the executive department.
Yes, that's
We
right, Your Honor.
we only craft the law under Section 24, Article 6. It says all bills on appropriation must originate from the House of Representatives. Then
That's
it
right.
goes to the Senate, and then we have a bicameral conference committee. The moment it becomes a law, then it has to be implemented on the part of the judiciary by the Supreme Court. On the part of the executive department, implemented by the office of the president and the various departments.
Yeah.
Okay, Congress has nothing to do with it. Not implement any item in the General Appropriations Act. We do not spend a single centavo from the General Appropriations Act. I hope the Supreme Court will take a different look at the
Second
pork
look.
barrel, because pork barrel, just take a look at the definition of pork barrel in the dictionary, and you just review the provisions of the Constitution in relation to appropriation. Now, let me go. I will be I'm sure I'll go to just 2 points more. Evidence. A while ago, mention was made on evidence. What is your understanding of evidence?
It constitutes proof of an alleged fact. It tends to prove the existence or the truthfulness of an alleged fact.
The reason why I'm asking this is because if you get a post at the Supreme Court, you will be in a position to correct an infirmity in our rules. It was in my understanding, memoriado since my school days. Hindi naman nagbago. Evidence is the means sanctioned by these rules of obtaining in a judicial proceeding the truth respecting a matter of fact, period. Judicial or quasi-judicial proceeding. It does not mention a judicial proceeding only. What mentions section quasi-judicial or administrative proceedings is Rule 133 Section 5 defines substantial evidence rule. Meaning, if we are to come up with a complete definition, an accurate definition of evidence, it should really mean to means sanctioned by the rules of court of ascertaining in a judicial, quasi-judicial, administrative proceeding the truth respecting a matter of fact. Because our rules of court mentions in Rule 133, Section 5, of what substantial evidence means. Is that correct, Justice?
Yes, Your Honor, that is the amount of evidence required in administrative cases, substantial evidence. Such amount of evidence that a reasonable man may accept as adequate to support a conclusion.
Another, very, very briefly, you're aware that acquires jurisdiction in criminal cases from the time of what? Acquires jurisdiction over a criminal case from the time when does the criminal court acquire jurisdiction over the person of the accused?
Upon the arrest of the person.
Very good. And from the time the criminal court acquires jurisdiction over the person of the accused, that jurisdiction is retained until the final determination of the case, and in fact, until the final implementation and service of sentence by the accused.
Right, Your Honor.
Tama yun, di ba?
Opo.
Okay, you have Article 99 of the Revised Penal Code. This refers to allowance for good conduct.
Yes, Your Honor.
Now, it says that whenever lawfully justified, the director of prisons shall grant allowance for good conduct, meaning it is the director of prisons who even orders the release.
Opo.
And
Yes,
once the allowance is granted, it shall not be revoked.
Right, Your Honor.
Is this not an intrusion into the jurisdictional power of the court to see to it that the sentence is fully served? Is it not that it should be the court who should order the release of the accused, of the convict already? The accused was convicted, so convict na siya. And then convicted, while in prison, he earned time allowance. And under the revised penal code, it is the director of prisons who will order the release. Is it not that it should be the court who should order the release because of our understanding that jurisdiction was acquired must be fully exercised by the court until the case is terminated, and the case is terminated by the service of sentence of the accused?
Since, Your Honor, there is a law which provides for the release of the convict on the basis of GCTA, I think he can be released once he is deemed to have already fully served his sentence through the application of GCTA, Your Honor.
So, remember, a while ago we were discussing about jurisdiction
Right,
versus
Your Honor.
procedure. Release is already a matter of procedure. I think it behooves the Supreme Court to fix this problem. One last question, Justice Padilla. We have a problem on service of sentence, and I'm referring to Article 70 of the Revised Penal Code. Remember, it says there that service of multiple sentences must be simultaneous, starting from the most severe, reclusion perpetua, actually it says death, up to public censure. But take note of this, notwithstanding the rule earlier mentioned in Article 70, the maximum duration shall not exceed threefold of the length of the most severe. And worse is the last paragraph, it says, in the second to the last paragraph, it says, maximum period shall not exceed 40 years. So a problem crops up. Here is a juvenile delinquent at 18 years old, raped, say, 50 girls, and was sentenced to life imprisonment, 50 separate sentences. At the age of 58, magkano ba? 18 plus 40, 58. Malakas pa siya. He will be ordered released because maximum period is up to 40 years. And worse is, while in Article 27, reclusion perpetua is 20 years and 1 day to 40 years. Last paragraph of Article 70 says reclusion perpetua must be computed at 30 years. I am reminded of the equal protection of the laws. Article 3, Section 1, no person shall be deprived of his life, liberty, and property without due process of law, nor shall anybody be denied equal protection of laws. There is, in my view, a denial of equal protection. Pedro was made to serve 40 years for his single offense, while here, an offender, 50 separate rapes, will be released after 40 years. What can you say about that, Your Honor?
It seems that there is, Your Honor. Your observation is well taken. But since that is provided in the revised penal code, it can very well be amended by Congress in the light of your observation, Your Honor.
I am raising that, Your Honor, because only the Supreme Court can declare that this is violative of Section 1, Article 3 of the Constitution. This Article 70 of the Revised Penal Code is unconstitutional. It violates the equal protection of the laws. Not Congress, masyadong matagal yan kung aasa pa kayo sa amin. That will be all, Your Honor. Thank you so
Your
much.
Honor.
Thank you, Congressman Veloso.
Yung boses.
Dado Peralta.
Yes.
Hindi nagpa-fluctuate. Good afternoon, Chief Justice.
Chief Justice.
Yeah, is there something wrong with the audio or video?
Your
There's
Honor,
something
the internet signal of Attorney Aricheta is low. So
Yeah. Anyway, I'm the next, so I can already proceed. Okay.
yes, Chief Justice.
Just how are you, Justice Presi? They call you Justice Presi, right?
Yes, of course, Your Honor. I'm good.
How's your husband?
He's good too, Your Honor.
We face in one, two criminal cases when I was a young fiscal. When we went for love.
I was told. Yes, I was told by him, Your Honor.
Collaborated in some cases also. Okay. Anyway, now you stated a while ago that the public has accepted or has been accepting the performance of the Supreme Court. Did I get you right?
Yes, Your Honor. Because I think in the survey, the Supreme Court is receiving good rating, Your Honor.
And why do you say that? Is that your opinion or based on the opinions of others?
My opinion and based on the opinion of others, Your Honor.
So the public is satisfied so far with the performance of the Supreme Court?
By and large, Your Honor, yes, I agree.
What about Congress?
So.
What about Congress? Oh, you need to answer that. Okay.
Thank you, Your Honor.
Of course, JBC is included.
Yeah, right.
Now you are teaching remedial law, and then you mentioned the three areas. The three areas that you will have to give attention. Because these are the problems that the Supreme Court is facing. Right? Number one is early disposition of cases. You want that there should be speedy disposition of cases. Are you aware that the Supreme Court has adopted measures in order to address the delay in the disposition of cases in the first and second level courts?
I'm very well aware, especially with the passage of the revised rules on procedure, where continuous trial now is required too. Not only in criminal cases, Your Honor. It's just a matter of how this will be enforced by the concerned trial court judges, Your Honor.
Have you heard also about the rules on small claims?
Yes, Your Honor. I think it has helped to a great extent in the disposition of cases, Your Honor.
We cannot only increase the jurisdictional amount. The threshold amounts in small claims, because Congress has not yet acted on our request to
increase the jurisdiction
of
yes,
the
Your Honor.
courts, so that we can increase the threshold amount in small claim cases.
Yes, that will be a good step.
Here, Congressman Singh Beloso is listening. And I understand that he's the prime mover for the amendment of the jurisdiction of first level and second level courts insofar as money claims are concerned.
That is good, Your Honor.
Early disposition of cases other than the small claim. You were talking about continuous trial.
Yes, Your Honor. Criminal and civil.
You were a judge for how many years, Justice?
A trial court judge for 10 years, Your Honor, as MTC judge for 6 years and RTC for 4 years.
Yeah, and I know that you have read the guidelines on continuous trial in criminal cases.
Yes, Your Honor.
You know if it is working, it is effective in reducing the trial dates in the resolution and the trial dates allotted for criminal cases?
I have read an article that this has been successful so far.
And you're also mentioning about rules on civil procedure, which we have amended.
Yes, Your Honor.
It became effective on May 1.
May 1, yes, Your Honor.
Aside from continuous trial, which we are now adopting pattern after continuous trial in criminal cases. Do you know of other innovations or new provisions that would address the problem of delay in the disposition or in the delay in the resolution of civil cases?
Yes, Your Honor, under the revised rules of civil procedure, aside from continuous trial, there are provisions which prohibit now the filing of motion for extension of time to file pleadings, papers, and other court submissions, except only for the filing of answer, where an extension for a maximum period of 30 years on top of the first original 30 years may be granted. Then motion for postponement shall not be entertained, except only on 3 grounds: force majeure, acts of God, and physical inability of a witness to testify. Then as to motions, they are no longer required as a matter of general rule to be set for hearing. For litigious motions, the other party may just be asked to file comment, after which the motion shall be considered submitted for resolution.
I will cut you there.
Okay, Your Honor.
Okay. So probably you have also observed from the contents of the pleadings that we have already gotten rid of allegation of ultimate facts. But
yes, Your Honor.
It's no longer allegation of ultimate facts, but allegation of statement of facts.
Yes. Evidentiary matters are now to be included, Your Honor.
Okay.
So everybody need not engage in fishing expedition. Everybody will now lay his cards or her cards on the table as early as possible, Your Honor. So that will make them prepare for trial at early on, Your Honor.
Do you think that our judges and lawyers are amenable or agreeable to all these innovations or amendments to the rule on civil procedure?
Well, as a general observation, there will always be resistance to changes, Your Honor. But eventually, they will realize that these are helpful tools to promote an expeditious disposition of cases, which must be one of the concerns also of lawyers.
You also mentioned some of the circulars that the Supreme Court issued during this pandemic, no? During this time. You
Yes,
mentioned
Your Honor.
about reduction of bail for
Yes.
indigent, reduction of bail of indigent, posting of in some cases recognizance instead of bail. We have also allowed the release of prisoners who have already served the minimum sentence provided for by law. We have allowed we have allowed teleconferencing.
Yes.
Then but there are concerns that by allowing PDLs, no, or the indigent PDLs, or requiring them to enter a plea before bail is granted, some say that is in violation of the rules, because if they enter a plea, then
Waiver of the
they
right.
are waiving
Yes.
the remedies to question the validity of the information,
Information.
the validity of the preliminary investigation. What is your take on that?
Yes, that is the rule. The rule is very clear that once you enter a plea, you cannot avail of those remedies that you mentioned, Your Honor, except only if the Supreme Court will provide that this is an exceptional circumstances that we are in, and therefore they may still avail of those remedies despite the plea.
Or is it not that it is also good to require them to enter a plea because there is already a reduction of bail bond, and therefore they can enjoy provisional liberty to ensure their appearance during trial. They have to first enter a plea, because by entering a plea and being absent during the trial, then trial will proceed in absentia.
That is right, Your Honor. Those are the benefits that may be obtained from the requirement that there must first have plea before bail.
But anyway, the accused anyway is given the choice. Integrity Board.
Oh,
It is some sort of ombudsman within the Supreme Court.
that's
In
good,
due
Your
time,
Honor.
we are now busy preparing the guidelines, and in due time we will be implementing the JIB. I think that is a
Good, Your
good tool
Honor.
to
Yes, I agree, Your Honor. I agree.
You mentioned about salary in Singapore, that the salaries of judges are higher than those in the private sector.
I read that article long time ago. I don't know if that holds true up to now, Your Honor.
I think the judges are now fully paid. I mean, they are now
They are adequately. I think so, Your
satisfied.
Honor.
You know how much, though that's a confidential, you know how much an RTC judge is receiving now?
No, I don't know, Your Honor. But I
You're not
believe
aware?
that we are now adequately compensated.
That's correct. Even the first level courts, through the generosity of Congress, during your time, you never receive any hazard pay. But through congressional initiative, they included a certain amount as hazard pay for judges, who is in the amount, I will not mention the amount anymore, but it's substantial. That's why Congressman Veloso is listening.
He is listening, yes.
So it's not correct to say then that our judges are lowly paid. I think the problem is the salary of those employees lower than the first level court judges and the second level court judges, like the stenographers. I think we have to address the problem of salaries of the support staff. The judges, as I said, are already
Yes,
satisfied.
I agree to that. I agree, Your Honor.
Now, I know you're very much qualified to the position. You've
Thank
been
you, Your
a
Honor.
judge for a long time. Aside from those that you mentioned during the questioning, and also the answers that you gave, if you joined the Supreme Court, what else can you introduce in order to help the court in addressing the problem of disposition of cases, both in the appellate courts and in the Supreme Court?
Your Honor,
In the
please.
court, for example, in the Court of Appeals, have you contributed something for the expeditious disposition of cases in the appellate courts?
Yes, Your Honor. With the Zero Backlog Project of former Presiding Justice Andy Reyes Jr., I was one of those who volunteered to help in the disposition of cases, although assigned to other justices who have already aged for how many years? Yes,
Can
Your
we do
Honor.
that? Can we do that in the Supreme Court?
Yes, why not, Your Honor? With the cooperation of all the justices and the support staff. Your Honor, please, I have observed in the Constitution that there is a provision which says that the Supreme Court may sit en banc or in its discretion by division of 3, 5, or 7. But as of now, I think you have division composed of 5 members, Your Honor. Is that